Firstly, a word on the subject of a Windrush generation public inquiry. How can one offer justice when one refuses to concede the injustices which brought about the necessity to offer it? George Lee. The rule of law has been regarded as a fundamental principle of modern legal systems, including the UK. It has been said to be as important in a free society as the democratic franchise, and even the ultimate controlling factor on which our constitution is based. Like parliamentary sovereignty, its meaning and extent is disputed. The most widely accepted meanings speak of several factors. Lord Bingham of Cornhill, formerly the highest judge in England and Wales, suggested the rule of law ought to mean that law is clear and predictable, not subject to broad or unreasonable discretion, applies equally to all people, with speedy and fair procedures for enforcement, protects fundamental human rights, and works according to international law. In the interest of transparency, one should be clear about what we are about to witness. The United Kingdom government made the decision to remove the Windrush generation from the UK. Apparently, the UK are such wonderful educators that, after 400 years of slavery and subservience of those who have become known as the Windrush generation, the decision had been made that assimilating them was not possible. Those were the words of Home Secretary Reginald Maudling to Prime Minister Edward Heath. To expel one group of citizens from any civilized state necessitates the removal of probably the most fundamental right, as it goes to the heart of the humanity of each individual who suffers such loss. This right being citizenship. It is, therefore, obvious that to do so lawfully requires removal of a fundamental constitutional right. It is accepted by all civilized states that such removal of this fundamental right requires the state doing so to adhere to certain norms. The bare minimum requirement is primary legislation which states overtly the abrogation of this right and from whom this right is to be abrogated. These are absolutes. It is notable that in the case of the Windrush generation, no such minimum has been adhered to. If this principle is not adhered to, any such legislation is deemed to be unconstitutional and probably retrospective in effect. The United Kingdom government's actions in disenfranchising the Windrush generation was definitely unlawful and unconstitutional. For certain individuals among this group, the removal of rights which took place was retrospective. There is another alternative. That is that the rights were not removed. Thus, the necessity to employ the Home Office to secretly and unlawfully terrorize the Windrush generation for half a century. That this has taken place cannot be denied, even by the brazen and unashamed United Kingdom government. What you are about to witness is not just a cover-up, but a complete deception. The United Kingdom claim that the Windrush scandal began somewhere around 2012. However, during this so-called inquiry only one piece of legislation is referred to. That is the Immigration Act 1971. To be more specific, only Section 3, Clause 8 of this particular piece of legislation. When any question arises under this Act whether or not a person is a British citizen, or is entitled to any exemption under this Act, it shall lie on the person asserting it to prove that he is. The terms of reference are restricted to the subject of the unlawful detention of members of the Windrush generation. The fact that the matters under discussion refer entirely to the Windrush generation, because Clause 8 was included in the 1971 Act, specifically to give Her Majesty's Home Department authorization to completely, and of more importance, secretly disenfranchise the Windrush generation, is entirely overlooked, to such an extent that one is left in amazement at the duplicity and audacity. The Home Office is given authorization to treat all matters concerning the Windrush generation as top secret. No responses to any inquiry are ever given to the applicant, his legal representatives or Member of Parliament. Each individual member of the Windrush generation is instructed to gather, literally hundreds of pages of information of whatever type demanded. These are then filed and never referred to again under normal circumstances. Decisions are never communicated to the applicant, who is never permitted his legal right to access to the file concerning the applicant, her or himself. As regards the decisions referred to, one does not know if any have been made, as the Home Office never responds to inquiries and there is no right of appeal. Besides, how could it be possible to appeal if there is never even an acknowledgement that any application has been made? The Windrush generation have in fact suffered a 52-year regime of terror at the hands of the Home Office, which has been one of detainment, incarceration, deportation and exclusion, moreover, without oversight or supervision. So, as you watch, please keep in mind that what you are witnessing is a deception. Astonishing is that the United Kingdom government still seeks to maintain that the Home Office and every Home Secretary since Reginald Maudling, initiator of the plan, was, and is, ignorant of its existence. After completion of this multimedia documentary, it was decided to go back and take a brief look at the Windrush compostation scheme, in order to expose the fact that no thought of the Windrush generation was given to its conception. So, let us turn our attention to the Right Honourable Baroness Williams of Trafford, speaking in the House of Lords, of the Windrush Compensation Bill. The compostation scheme, allows those who have suffered to avoid court proceedings in pursuit of justice. Let us correct the Lady Baroness. The compostation scheme allows the UK government to avoid court proceedings. That is the primary reason for refusing to allow the Windrush generation funds, so they may be legally represented. The Right Honourable Lady explains this heist rather ineloquently. And to discharge our financial duties to Parliament responsibly, but this bill will ensure that expenditure under the scheme meets the expectation of financial regularity, both in relation to the 1932 Concordat between the Public Accounts Committee and the Treasury, and the principles of managing public money. There you have it, in their own words, the Windrush compensation scheme is a United Kingdom government con. Windrush generation were of the belief that the purpose of this process was to discharge a financial duty to the Windrush generation, not the UK government's Parliament or Treasury Department. The Right Honourable Lady speaks of responsibility to the UK government, without any thought given to the fact that proceeding in this manner is undoubtedly not fit for the purpose supposedly intended. Her statement is imparted with pride, with the undoubted awareness that what is being said is in fact morally and ethically bankrupt, just like the government she represents. Windrush generation begs to suggest that restrictions designed to govern how Parliament disperses the King's currency ought not to be taken into account when giving consideration to compensation payable for the wrongful acts of Parliament perpetrated upon the Windrush generation over a period of half a century. Indeed, none of what is here stated by the Honourable Lady to have been considered are legitimate factors for the limitation of amounts payable as damages, and prevents altogether deliberation being given to the far more consequential matter of aggravated damages due to every member of the Windrush generation and their descendants as a result of the long list of criminal misdeeds perpetrated against them.
I think it's important to be clear about this, is that it's a let's say a unique situation in the sense that this, because of the 1971 Act, and it gave all Commonwealth citizens that were here before 1st January 73 that deemed status, which for years, so by definition, because of the deemed status, there's no documentation issue. And I think what's partly, obviously we'll go through a proper lessons learned exercise, but partly I think what's happened is that over time, naturally, many people would have, including in the working in immigration enforcement and stuff, they wouldn't necessarily have. You can imagine maybe sort of in the 80s and 90s, they're a bit closer, that time period's closer to when that deemed status was given, but over time, I think that maybe people sort of lost sight of that and what that was, and then applied the sort of the judgment we've been talking about.
First off, I'd like to very much thank the Home Secretary, the Home Office, for releasing to Anthony Bryan and Paulette Wilson their case files. Paulette Wilson and Anthony Bryan are two people who arrived here as children as part of the Windrush generation and have lived here continuously ever since. And they came to give evidence to us a few weeks ago about how they came to be locked up despite actually not having done anything wrong. And we asked on their behalf to see their case files. And I'm really grateful to the Home Office that you didn't say, fill in this form, fill in that form, somebody else has got to ask. And I think it was very encouraging in terms of transparency that the Home Office said, yes, we will give them their case files. And they've given us their case files in order to help us understand what actually happened in the system. So we've got Paulette's case file here, and we've got Anthony's case file here. So we can actually see behind the scenes what was actually going on that led Anthony and Paulette to be detained. So thank you very much for letting us have them, and thank you to Paulette and Anthony for letting us use them as part of this inquiry. I think my first question I'd like to ask, really to set the scene, is for really both the Home Secretary and Mr. Williams to just really place on the record for us that the human right of being at liberty and not being locked up unless there's a reason to lock you up, for the state not to take you away from your home or your work and to take you from your family and lock you up, is a very important indeed human right.
Yes, thank you very much, Chair. First, thank you for your opening remarks as well. And before I get to that, may I just also take this opportunity, since it's my first appearance in front of the committee, just to first thank the committee for the role it plays in holding this government to account, and in particular on this occasion holding my department to account and scrutinising the activities of the department. I think that's very welcome. In fact, I think that kind of scrutiny is essential. In terms of the issues, I understand the committee's focused on, as at least for today's session, on human rights and especially around detention policy. I understand there may be some questions in particular, of course, around the case of Miss Paulette Wilson and Mr. Anthony Bryan. Can I just say at the outset, when I first heard about those cases, I was appalled by what I heard and what had happened to both Ms. Wilson and Mr. Bryan. As I learned more about the cases, including when you had them in front of your committee as well, and went through in detail and heard testimony from themselves, that I found that both listening to that and then looking at the transcript, both very moving and very thought-provoking in a way about what lessons we can learn for that, and perhaps we can get to that later as well. And I also want to take this opportunity just to add my apology to the apology already given by the Immigration Minister, and just put on the record publicly, I am very sorry for what's happened to both Miss Wilson and Mr. Bryan. And as you've just said as well, no one should be treated like that, not in a country, a democracy like ours. And what happened was profoundly wrong. And I'm pleased that you're scrutinising as well, because that will help us. We still have lessons to learn from that as well. And I think I said probably in the first day I became Home Secretary that I felt it personally, because I felt that because my parents are Commonwealth citizens as well, or were Commonwealth citizens when they from the country they arrived from, not the Caribbean, but I felt that it could have been my parent, my aunt, my uncle, and so I felt very personally, how can someone who's been in this country for such a long time be treated in that way. I hope that with both Miss Wilson and Mr. Bryan, that we'll want to ensure that they get the compensation that they deserve. And I'm not pretending that's enough in any way makes up for what's happened, but I want to see what we can do to try and put some of the things right. But I also want to make sure we draw all the right policy conclusions by learning the lessons. If that's
and it's very interesting and concerning to us on this committee that in both these cases MPs had got involved, and yet still the files hadn't been picked up and looked at as in a way that you now acknowledge they should have been. And interestingly, and I will just close with this, there isn't a scintilla of evidence on any of these files casting doubt on what these applicants had said right from the start. Their stories have been consistent and holistic, and that is what is particularly concerning when one looks at them, that they were, if you like, equally consistently challenged rather than accepted and verified. But what do you think of what we've just heard, Mr. Javid?
Well, please help me, this is my home. And that says it all, really. So she was asking for help in the case of Miss Wilson. She was asking for help, but it applies obviously in both cases, and she didn't get it. And obviously it's her home. It's the only home she knew. And so I think because I am new to the job, I hope to use it as an advantage to bring a sort of fresh set of eyes to what happened, what went wrong in these cases, because obviously something massively went wrong. And so why it happened, and what lessons can we learn from it, because what's happened has happened. We're all sorry for it, but how can we try to make sure this kind of thing, or nothing like it, sort of happens to others? And one of my sort of early lessons, as it were, from it, is that it seems to me that I think this is the most sort of fundamental point from what I've seen so far from the system, is that the sort of whole immigration enforcement system, taken as a whole, it is not set up for a situation where people have deemed leave. So those people had deemed leave under the 1971 Act. I don't think that's been taken into account in the system. Sort of, there's not much evidence that that was sort of thought through. And I can see why. I can see how that happened, because that, I think, applies to successive governments as they've implemented different policies, what we might call, what I've been calling the compliant environment policies on different checks to prove your status and so forth. There's more reason for people to be asked to prove their rights to be in the country. And then when that then comes into contact with people who are deemed leave, the system then wasn't able to respond to that. And then linked to that is something else that you've rightly touched on, Ms. Bruce, is even then when that individual comes into contact with the system and says, okay, I need to get some documentation to prove my status, the system puts the entire burden of proof on the individual.
Yes. Yeah.
So the point is that in both those examples that you gave, in both Ms. Wilson and Mr. Bryan, that they sent in either their applications, their letters and stuff, or you've got here some really good examples of where Ms. Wilson, for example, her daughter wrote in a number of times, her MP writes in, her daughter said, my mum's been here this long, but the system says, well, you've got to prove that.
Yes.
And whilst you could have, because the Home Office, obviously a big part of the public sector with easy access to
National
DWP
insurance
records, school records, and as you say, Treasury, HMRC, it doesn't do that, and it puts the entire burden on you. And the problem with that approach, just as it is that the system isn't set up for those with deemed leave, so that means it is much more set up for those who would have had to already have proven their status. So what it means in fact is that if you are a more recent migrant to the country, so that's 10, 15 years or whatever, because you would have had to get your status, if you're legally here, you would have had to get some status to prove that. And also you might want to, quite rightly think, in a 5 years' time or something, I might want to get leave to remain, and so you will keep your documentation, so you'd have maybe a habit, or you might have been advised to keep your bank records and things like that. There's absolutely no reason why anyone who had deemed leave from the Windrush generation would have to do that. Why should they have to do that? Because as far as the law's concerned, they're absolutely rightly here. And that's why I think in many cases people are being asked for proof that they couldn't possibly provide, and then even once they're being asked for the proof, there was no help provided. So some of those lessons, not all of them, I still think we've got a lot of lessons to learn from this, and we're going to have we're in the process of starting a full review of lessons learned, which will take time, but I want to have proper independent oversight of that, make sure it's done properly. But some of the lessons have already been learned. So with the Windrush task force that's now been established to make sure that we're doing everything we can to help everyone in that generation. So there's now over 150 sort of full-time people in various locations working with anyone who's approaching them from the Windrush generation. And what's happening now is the kind of thing, if it happened before, then Ms. Wilson and Mr. Bryan would have not gone through any of this. Because what's happening now is that you approach task force and the caseworkers are instructed to be sympathetic, proactive, to use the entire public estate to gather information on their behalf, to make it as easy as possible. And what we're finding when they do that, they are actually able, if someone's coming in for an interview, so they call up or email in, they're invited in for an interview. If they want it face-to-face, they can do it on the phone. Many are choosing to come in face-to-face, and within a couple of days, they can be issued with their documentation. They can get the letter within a couple of days. And the reason that's possible is because that individual, the caseworker, can call up HMRC, contact them immediately, or schools. You know, we've had individuals that have said, for example, that, you know, I went to such and such school, you know, when I was a child and for 10 years, and I've seen old case where the caseworker would say, well, prove it. And the individual say, well, I can't, because the school doesn't exist anymore. Yeah. It's merged with this school and that's happened. And then in the old system, the caseworker would say, well, that's up to you. You've got to come up with some proof. But now you just can call up the DFE or find it, or the local education authority, and find it. So it's changed for that generation. You're too late, but at least it's happened. So it's a big difference. And also, then, last point I'd make on that, we've also put in place what we call the Windrush scheme. So now that all the individual has to do is fill in one quite straightforward form, and they don't have to decide, because this was part of the problem. Because in the case of Miss Wilson, for example, as I understand it, in her original application, she'd applied for the right to stay. I think actually she was probably, it wasn't straightforward to what she was actually applying for, which route. And she probably wasn't aware she already had, obviously I think she wasn't aware she had deemed leave. And so it was a sort of, you can say, the wrong type of application, but why she wouldn't have known. And the same with Mr. Bryan's. I think he was originally trying to use the human rights route, which he didn't need to. So now, to deal with that problem, what we're doing with the Windrush scheme is you just fill in one form, and the caseworker works out what's the best route for you, advises you on it, and actually then goes away and works with you and gets the proof and brings it to you. So that's what's happening now. It didn't happen before, and those lessons are being learned.
I think it's important to remind ourselves that the main thing we're concerned with this afternoon is the human right not to be detained, and an inquiry into why these two individuals were detained. And I'm afraid I'm still not clear why it was felt necessary or proportionate to detain either of these people in the face of the evidence. Because you see, Home Secretary, you said at the beginning, no one should be treated like this in a democracy. But the reality is that they were. And it's very important for us to establish why, so it doesn't happen again. Do you appreciate that?
Yes.
I mean, those of us who are members of Parliament have constituents who are in this situation. I saw a lady at my surgery last week in Edinburgh in a similar situation to this. She came to see me because she is very worried about what's happened to people like Anthony and Paulette. And so do you understand that what this committee is trying to do is work out why these two individuals were detained in the face of all the evidence, so that we can stop it from happening again?
Yes, Mr. Chair, you're right.
Well, I wonder then if we can just look a little bit more closely at Anthony's file. And you've got the grid there, and I think, Mr. Williams, you have the file in front of you. I wonder if you could look, first of all, at his initial application from 27th April 2014, which starts at page 15 and goes on to page 66. Now, I don't need you to go through it in detail, but I think you'll agree with me that at page 46, he stated that he's lived in the United Kingdom for 50 years and that he's been here since he was aged 9. I think you'll see that at page 46 of the file. It says, I do not know any country, Jamaica.
I do not know my
country, Jamaica.
Do not know my country, Jamaica.
Yeah. So we've got the gentleman saying that he's been here for 50 years, he doesn't know Jamaica, and he came to the UK when he was 9. And then a month later, if you turn to page 67, we've got a letter from his solicitors. I think Fiona referred you to that. And it encloses pay slips and national insurance records. Did you see that?
Yes, I'm sorry. The papers I have don't have. I don't think they have those page numbers on them.
It should be in the bottom right-hand corner.
Are we?
Yeah.
Are we on?
Yeah,
that? Okay.
Basically, what you can do is you can follow the points Joanna's making by going through on the summary.
Yeah.
It doesn't matter if you can't find the thing, but just for reference, we've paginated it.
You can take it from me that this letter, dated 18th of May 2015, has Anthony's national insurance number in it. And it also contains his national insurance records. And if we go to them, and they're, for the sake of the pagination, at page 215, we can see a letter from HM Revenue and Customs dated 27th February 2013, addressed to Mr. Bryan, saying, "Our records show that you currently have 13 qualifying years up to 5th April 2012. This includes 24 national insurance contributions paid or credited in the years up to 5th April 1975. So at that stage, back in May 2015, the Home Office had evidence from another government agency that this gentleman had been here prior to 1975. That's right, isn't it?
It sounds like it from what you're saying, yes.
And there's not anything on this file to contradict that, is there?
If I can assist you with that. Nothing.
So what I'm trying to get at, and what I'm trying to understand is, why in the face of this evidence, including evidence from government departments supporting the fact that this gentleman had been here working and contributing to this society for so long, you thought, your department thought it was necessary and proportionate to detain him under threat of being deported to a country he said he didn't know, when they had evidence of a family connection here, a work record here, a whole life in the United Kingdom. Why was it necessary to detain him? I mean, let's just be clear what detention means. It means a van comes to your house and takes you away from your loved ones and locks you up. Now that's something in this country we normally only do to criminals after due process of law. Why was it felt necessary to do it to Mr. Bryan when the Home Office had written evidence from another government department that he had been contributing national insurance contributions in this country prior to 1975 and up to 2012?
No.
The mistake explanation might, with all due respect to Mr. Bryan, just about be acceptable if there's only one person affected. Absolutely. But these two people that we've heard evidence from, Mr. Bryan and Ms. Wilson, they're just the tip of the iceberg. They're just exemplars of what's happened to other people, aren't they?
Can I just add to it at that point and say that I wouldn't want anybody to run away with the idea, or you to run away with the idea, Mr. Williams, that there was an initial mistake and everything flowed from that. There was a mistake every single day, because all the evidence was in the file, and anybody who looked at the file at any time would see, as we have all done, that was in the file for every single day. And as the machine ground forward, that material was in the file for anybody to read when they locked him up, having, as Joanna says, put a van at the end of his road, banged on his windows and doors, and took him away and locked him up. So could we move beyond the idea of, could we ask you to leave the idea of there being an initial mistake? There wasn't an initial mistake by every single person who took this file to the next stage, which then ended up with Mr. Bryan being locked up. And then David.
So that caseworkers might hopefully have been exercising common sense where they might want to follow up information with another agency. Does that get done ever?
Well,
I mean, within the department,
yeah.
Are there examples of where a caseworker will contact DWP or HMRC to establish that information? Has that happened?
Well, it's happening now through the...
No, I'm not asking what's happening now.
Task force.
Did it ever happen prior to the last couple of months?
I think it would... I think I said earlier on it would not have been standard practice at all, no.
So we're not talking about a question of common sense, we're talking about a question of policy. Is that right?
Well, Well,
I mean, either it happened or it didn't happen.
I can't
Or
tell you
your
about
caseworkers
historic
lack common
cases. I mean, I
sense.
haven't been in the department long enough to tell you about.
Well, no, but
what
perhaps
may
Mr.
not
Williams
happen.
can answer that question. Prior to this becoming a public scandal in the last couple of months, either all the caseworkers lacked common sense in dealing with cases, which I kind of doubt, or it was the policy of the department not to do this. And I'd just like to be clear which one.
Well, I think one thing that is certainly clear is that if you the burden of proof has been on the individual, and then therefore it could well be in these cases that as whatever information is being provided to that caseworker, instead of the caseworker thinking, well, either that's enough or I need to, there might be, that's sort of pushed me in a direction where they could get information from another part of the public sector. Instead, it's sort of been left rather than sort of, that's what I mean by applying a bit more common sense to the approach.
But no, you see, I'm really quite worried about this, because if it was left to common sense, then it is likely that somewhere along the line, some caseworkers would have exercised some discretion in this case. And I have the feeling that none ever did, which leads me to believe that it wasn't a question of caseworkers making judgment. It was the policy of the department not to do this. Possibly written down, possibly not written down, and I'm just keen to know which. And the answer to that will be whether it was ever the case that a caseworker would seek information from another government department.
I think, as a general point, probably not. I mean, the guidance, for example, for the NTL application, which is the one that most Windrush would have done, says you must provide evidence of continuous residence in the UK during the period in question, such as council tax letters, letters from a GP confirming dates of attendance, letters from a school college confirming dates of attendance, electricity, gas or water bills, letters from employers confirming employment. That's an illustrative list. It doesn't say you have to provide all those for every year or things like that. I think it's probably true to say that our interpretation and our application of this guidance became rigid over the years and quite inflexible. And when applied, in particular, to Windrush people who've been here 30, 40, 50 years, if you apply that rigidly over that sort of time period, it becomes almost impossible. And I think that's the mistake that's been made, and that's what we're now seeking to...
Can I just pick you up there and say, is it really, it's not rigidity, is it? It's perverse. Because it's not just that they're inflexible, but the detention flies in the face of all the evidence that is in the file of their arriving in the country as a child and continuous residence, and indeed shouting relatives, letters from MPs. Now, that's not rigidity, that's perversity, isn't it, if you then lock somebody up?
Yeah, Chair, I was referring there to in my mind there's a separation between the UKVI process and then the immigration enforcement process. I had in mind this guidance I referred to.
Well, just have in mind somebody being locked up,
yes,
not the processes.
Yes, I know.
And work back from there.
Chairman, I'd just like
David.
to back, before we come to the question of detention and the legality of that, to come back to the approach that's been adopted with regard to considering whether persons are entitled to be in the United Kingdom. And here in the note we've had, referring to the Immigration Act 1971, Section 3, Clause 8, and it reads, when any question arises under this Act whether or not a person is a British citizen or is entitled to any exemption under this Act, it shall lie on the person asserting it to prove that he is. So the question of onus of proof was put in the 1971 Act. Now, I don't think it was a sensible thing to do, because the framers of the 71 Act must have realised that there were a lot of people who had come in before 71 and would not have had any documentation to show that they were entitled to be in. And then you put in a provision saying that you've cast an onus on them to prove that they are entitled to the provisions of that. So I think its problem stems to a large extent to the way in which that clause was put into the 71 Act.
We kept on asking her to make an NTL application, which cost £229, and I don't think she was actually obliged to make an application to prove her status. It would have been sufficient for her to amass the evidence and present that to us.
As she did. She wrote,
yes.
wrote to the department explaining that she'd been in a children's home, that she had worked here, lived and worked here pretty much all of her life. So even within the confines of the 71 Act that Lord Trimble quoted, she had provided evidence that she had been here.
Yes, and I agree, and I regret that was not brought together by us and treated in a sympathetic and holistic way. That's what we should have done.
Are you telling us definitively that there was not a policy of ignoring this information when it appeared in someone's case file?
Ignoring in what sense?
So in Pauline Wilson's case file, there is information that she had been in the country long enough that she was part of the Windrush generation, and yet she was still detained. Given that there was information within her case file that showed that she should not be detained, why was she? So what was it, an error of judgment by an individual case officer, or was there a policy that said that we do not consider this information because it has not been presented to us in a particular form?
No, I don't think that is a policy. I think that before detention took place, there should have been a more searching and rigorous examination of the evidence.
In which case, who is responsible for the fact that that was not done? If the right thing was that somebody with responsibility for this case file should have looked at it and said, this lady is a British citizen and should be allowed to carry on with her life as per usual. Why? Who was it who made this disastrous error of judgment?
It would have been a person in immigration enforcement.
And are they still in post?
Well, I do think I just need to be clear. I'm not saying there was a willful approach by the department in this case to ignore or malevolently act.
I understand,
I think
and
they
I'm
acted
prepared
sincerely.
I'm prepared to accept at face value your statement that there was no departmental policy. But if that is the case, then an individual working within the Home Office has made a grievous professional error which has had the most profound impact on someone's life. And surely there must be some system to hold that person to account.
Well, you're basically asking me whether we should take disciplinary action against somebody.
Or would you expect there to be procedures in place within the Home Office to make sure that when this sort of thing happened, people were held to account? She wrote,
yes.
wrote to the department explaining that she'd been in a children's home, that she had worked here, lived and worked here pretty much all of her life. So even within the confines of the 71 Act that Lord Trimble quoted, she had provided evidence that she had been here.
Yes, and I agree, and I regret that was not brought together by us and treated in a sympathetic and holistic way. That's what we should have done.
Are you telling us definitively that there was not a policy of ignoring this information when it appeared in someone's case file?
Home Secretary, before you saw these files, you gave evidence to the Home Affairs Select Committee about the Windrush generation.
Yeah.
And you said, I would not describe it as a systemic problem in the Home Office. Could I ask you whether or not you could revisit that thought? Because what we've got here is two separate files with two completely separate teams dealing with them all the way through. There was no connection between these two people, no connection between the teams that dealt with them, and yet exactly the same outrage and human rights abuse occurred, which was they gave piles and piles of evidence, and yet they were locked up wrongly. Do you really think that the Home Office is so populated with people making wrong decisions, cruel decisions that have terrible consequences? Surely it's got to be, on the light of just these two files, it's too much of a coincidence, isn't it? It's a systemic problem, isn't it?
And I think, first of all, just on what Mr. Williams said, the reason, and I think it's important to be clear about this, is that it's a let's say, a unique situation in the sense that this, because of the 1971 Act, and it gave all Commonwealth citizens that were here before 1st January 73 that deemed status, which for years, so by definition, because of the deemed status, there's no documentation issue. And I think what's partly, what we'll go through a proper lessons learned exercise, but partly I think what's happened is that over time, naturally, many people would have, including in the working in immigration enforcement and stuff, they wouldn't necessarily have. You can imagine maybe sort of in the 80s and 90s, they're a bit closer, that time period closer to when that deemed status was given. But over time, I think that maybe people sort of lost sight of that and what that was, and then applied the sort of the judgment we've been talking about.
But you'll be able to see it. They report the fact that they're banning the daughter from attending with the mother. And I must say, when I saw what the daughter had done on behalf of her mother, it was all I could do not to stand up and cheer for this woman, because she was doing what any daughter would do when the mother was being subjected to a terrible injustice. This is what she said, and this is the file note from the Home Office. I advised her mother that her daughter would not be allowed into the building in future. The daughter started to swear, stating, "You are an effing B." And you can understand, can't you, why she would say that. You are an effing B. You can pee off. It's my mum. This is what was going on. There was extreme distress. There was piles of evidence. There was the lawyers, but there was this other strand, which was extreme distress, which instead of being responded to by the department, they banned the daughter and locked her mother up.
Just coming to the question of detention again, I take it Mr. Williams should now you'd be of the view that the detention was of Anthony and Pauline or Paulette was not lawful, or do you want to try and justify it?
It's certainly, I'm not a lawyer, it's certainly wrongful, and yes, I don't think it was lawful.
Yeah, I think you're right.
Don't these files for both Anthony and Paulette just show a repeated refusal to engage with facts being presented, not just by the individuals, but by their solicitors, by their members of parliament, and by other government departments? And that's what they show, isn't it? Repeated failures to engage with those facts.
I think they do show an unwillingness to reach out and work with what you might call a witness of credit to help them establish their position, yes.
Well, there were plenty of witnesses of credit. There was another government department. Before I became a member of Parliament, I worked in the courts of law for years, and when we were trying to establish people's employment records, the records of HM Revenue and Customs were accepted by a court of law. Why wouldn't the Home Office accept the evidence of HM Revenue and Customs regarding Mr. Bryan's residency in the United Kingdom? Why not?
Yeah, may I answer that? Or try to. I think what this shows is that in these cases, and obviously as we go through this and learn more, possibly other cases, is that, but since we're talking about these two cases, is that throughout the process, when both Ms. Wilson and Mr. Bryan come in contact first with the Home Office, and then they try to make their case and have others on their behalf, and as the Chair and others have said, I mean, absolutely, it's incredibly distressing, loads of anxiety, it's real, sort of hugely huge impact on the individuals, but not just them, but their family, their friends and things. So, of course, it's what's happened. That's why I started off by saying I was appalled to see what's actually happened here. But why, trying to get to the why, so we can learn from it, is, I think, during that whole process, there hasn't been enough common sense applied by the individual caseworkers involved, looking at things like, the letter from HMRC, the letter from the daughter in the case of Ms. Wilson, and just thinking, well, hold on a minute, I can just contact HMRC now and get verification of this, and that's fine. And there hasn't really been a very sort of thoughtful approach, an individual, a sympathetic approach, where one would you'd sort of think, look, this individual seems to have some really good reasoning here. They've provided me with what looks like some convincing evidence, and let me take the initiative, me the caseworker, take the initiative to try and learn more and find out more. And instead of doing that, which I would say is more of a common sense approach, I think what's happened is it doesn't tick all the boxes, and therefore you don't have the right to be here, and therefore we must start the process of removal.
But you see, I hear what you're saying, Home Secretary, but when the Home Office has a letter from another government department to HM Revenue and Customs, an official letter setting out national insurance contributions, what's the need to contact HM Revenue and Customs? Unless you think it's a forgery and it's been submitted by a solicitor, it looks pretty genuine to me. I don't understand this explanation that they needed to be proactive and contact. It seems to me they weren't even engaging with the letter. They weren't even engaging with the evidence they were being given, never mind following up on it. They were ignoring the evidence, prima facie evidence, that this man had a long employment record here.
Well, obviously each case is going to be different, but what you've said is it's concerning. As we look through the file now, as Mr. Williams has said as well, it seems that there's been a series of mistakes over a period of time.
You see, people might be forgiven for thinking that this is either gross incompetence or a deliberate course of conduct, ignoring evidence in order to perhaps reach some target for detention and deportation.
During the JCHR hearing, it was admitted by the Home Secretary and the representative for the Home Office that the behaviour of the Home Office was unlawful. All aspects of the behaviour of the Home Office towards the Windrush generation since 1st of January 1973 has been unlawful. During this hearing, regarding arrest and detainment of members of the Windrush generation, it became clear that the Home Office had a policy which amounted to the terrorization of one small group of United Kingdom citizens for the purpose of intimidating as many as possible into leaving the United Kingdom. What needs to be highlighted here is the declared aim of the Immigration Act, 1971. An act to make provision for British nationality and for citizenship of the United Kingdom and colonies, and for purposes connected with the matters aforesaid, to amend and replace the present immigration laws, to make certain related changes in the citizenship law, and enable help to be given to those wishing to return abroad, and for purposes connected therewith. This expression, for the purposes connected therewith, is an absolute gem. It is a wonderful euphemism for actions lawful or otherwise, in order to meet the objectives the government has set and secretly tasked the Home Office to execute. Reminiscent of instructions given to MI5 or MI6, with the target being an unsuspecting group of citizens who did not, and do not, have the sense of cynicism required to recognize what was being done to them. The first thing to discern, from the stated intent of the Immigration Act 1971, is to enable help to be given to those wishing to return abroad. There was no one wishing to return abroad. Windrush generation were even afraid to go on holiday, in case they were not permitted to return. The UK government has stated repeatedly, clearly and categorically since 1951, that they wish to remove people of colour, meaning black, and to some extent Asian people, from the UK. Anyone who reads the stated aims of the Act, declared in the Cabinet discussions, could be under no illusion as to the intention. What is little known is that by 6 February 1951, Home Secretary James Shooter Ada wrote a memo for the Cabinet, offering 3 options for the expulsion of the Windrush generation. applying to British subjects, the black ones, the same controls which applied to aliens. Of deporting some categories of British subjects, the black ones. Or of returning those who arrived as stowaways. To be clear, the plan was to allow black Commonwealth subjects, perfectly entitled to entry into the UK, to save up, pay for their passage to the UK, arrest them when they arrived, and then send them back to where they had come from, as stowaways. These suggestions are very similar to those suggested, in 1971, to the Cabinet, by Reginald Maudling, at the behest of Enoch Powell. These suggestions were rejected, only because there was no way of disguising the fact that they targeted black subjects. So, the illegalities inherent in the Immigration Act 1971 was the culmination of more than 20 years plotting by the UK government. However, because of the media outcry and the behaviour of members of Parliament, such as Powell and Maudling, desperation had led to a complete disregard for legality. There was an attempt to effect the desired change by offering paltry sums to black people to get them to volunteer to leave the UK. However, the amount offered evidenced what they considered to be the real value of black people now the war was won, the country rebuilt and decently stocked with ex-Nazis. It leads one to contemplate the fact that 1838 is still within the minds of both the British and the Windrush generation, with one being master and the other slave. The second part of the statement, namely, for purposes connected therewith, is the important part. As the attempt to get Windrush generation to volunteer to leave had failed, this part of the stated aim became the remit of the government's attack dogs within the motherland since 1792, the Home Office. They were tasked with the mission of removing the Windrush generation by force. One ought to repeat, the primary methods used were to be detention, incarceration, deportation, and exclusion. It is clear that observance of the events at the featured JCHR hearing makes it clear that an unlawful conspiracy was, and continues to be, in progress. By dint of Section 3, Clause 8, the United Kingdom Parliament gave the Home Office permission to treat as top secret and to ignore all applications made by the Windrush generation regarding every aspect of their status in the UK. Even today, not even a parliamentary committee or an individual member of Parliament engaged in an inquiry concerning the misdeeds of the Home Office may insist upon access to the files held by the Home Office concerning the Windrush generation, even though such refusal has been judged by the courts to be unlawful on more than one occasion, with the circumstances being almost identical to that of the Windrush generation. Incidentally, the story told about Shooter Ada's recommendations to the Attlee Cabinet came from his autobiography. It is important because what was being suggested was unconstitutional and unlawful. That is the real reason these suggestions were rejected. This story, however, goes a long way to providing an understanding and explanation of why the Home Office was tasked to disenfranchise the Windrush generation in such a terroristic manner from 1st of January 1973. Let us go back to 1948 and the Empire Windrush. Clement Attlee wanted to divert the Windrush to Africa and was told that those aboard the Windrush needed no permission from the Jamaican authorities to leave Jamaica and no permission from anyone to land in the UK. In fact, they had as much right to entry as he had. They were United Kingdom subjects, exercising their right to internal migration, not immigrants. In short, they had as much right to migrate to the UK as Attlee himself to migrate from England to Scotland. In terms of who was a UK subject, the turning point came 1st of July 1962, with the coming into force of the Commonwealth Immigrants Act, 1962, CIA 1962. In this legislation, stringent restrictions were placed on Commonwealth citizens. From this point forward, the movement of subjects of the Empire into the UK was one of immigration. Let us call those who arrived before the CIA 1962, pre-1962 CUKCs. In arriving at the conclusion that pre-1962 CUKCs must be entitled to the full benefits of British citizenship, compatible with pre-1962 CUKCs being recognised as having rights that put them in a de facto position, giving rise to an entitlement to British citizenship. Prior to the CIA 1962, and the coming into force of the immigration controls it introduced, pre-1962 CUKC's situation was subject to no restrictions on their entry or residence in the UK. 1. It follows that these persons possessed a status that was entirely indistinguishable, both in fact and law, from that of any other citizen of the United Kingdom and Colonies, CUKC, then residing in the UK. 2. Among such other CUKCs, then residing in the UK, were all those people born in the UK, or descended from a parent or grandparent so born, i.e. the primary factors that would later be employed to distinguish a class of person, upon whom would be bestowed the status of British citizen by the British Nationality Act 1981. 3. It follows that pre-1962 CUKCs had migrated to the United Kingdom in reliance on the possession of a status that was in every respect equivalent to that possessed by persons who went on to become British citizens by operation of the BNA 1981. 4. While legislation long post-dating their arrival in the UK sought to apply threshold conditions to the attainment by pre-1962 CUKCs of the status of British citizen, none of these statutes could be effective to deprive such an individual of the status attained through active and timely reliance on the pre-1962 state of the law. 5. To hold otherwise would be contrary to the general presumption against interpreting statutes in a way that retrospectively affects acquired rights, for example, the express provision made for persons who are to automatically acquire British citizenship under the BNA 1981, Section 11, does not touch on the question of whether those arriving as CUKCs prior to 1962 should retain the rights they acquired as a result. Furthermore, neither did the Immigration Act 1971 touch upon this subject. 6. Thus, it can be perceived that nothing has occurred in any legislation enacted by Parliament which lawfully removes the status of UK subject, citizen, from pre-1962 CUKCs. Yet, from 1 January 1973, this lawfully acquired and never rescinded or abrogated status has not been recognised by His Majesty's Home Department. As it was not possible to distinguish between pre- and post-CIA 1962, this is the point in time at which the entire Windrush generation became the primary target of the Home Office through the unlawful enforcement of Section 3, Clause 8 of the Immigration Act, 1971. The entire Windrush generation were told that if they considered themselves to be citizens of the UK, they had to prove it. However, no matter what evidence was produced, it was never enough and, quite simply, ignored. The worst thing was the refusal to state by the operation of which legislation they depended in order to make their decisions. This is why the charade witnessed in this JCHR hearing is a deception. The producer of this multimedia documentary presents the above as fact, because it is lived experience, and much more could be said, but one would need an entire series. Moreover, this ought to provide a better understanding of the despicable treatment of the Windrush generation, brought to public attention by the Windrush scandal, and highlighted by the JCHR hearing, featured in this production. In closing, the producer of this documentary has repeatedly requested His Majesty's Home Department to state which legislation, enacted by Parliament, is relied upon when stating that pre-1962 CUKCs were not lawful UK citizens. This question has been put to the Home Office repeatedly since 1988. To this day, no answer has been forthcoming, whether put by the applicant himself or his lawyer. Without an answer to this question, it must be assumed the UK government, represented by the Home Office, has acted and is acting contrary to law. The evidence indicates that no such legislation exists. If that is the case, it is clear that pre-1962 CUKCs have been denied their constitutional rights since 1 January 1973. What is the legal remedy therefore? Does the United Kingdom government not agree that 36 years is long enough to wait for a definitive answer to one question, or are they deliberately obfuscating, waiting for every member of the Windrush generation to die? If the United Kingdom government continues to refuse to proffer detailed responses to the discernibly correct assertions being made in this multimedia documentary, one is left with no alternative but to conclude that the intention is to continue the reprehensible dehumanization of the Windrush generation until every single individual member is dead. Is that not tantamount to the premeditated murder of an entire group of UK citizens? One may say that this is an overly strong declaration, but if you eliminate all of the means by which an individual may survive in a modern society, and as a result, he ends up dead, how else should it be described? The circumstances of the Calais children are identical to that of the Windrush generation, in that the Home Office actively and unlawfully denied them access to human and fundamental rights in order to achieve the objectives of government. It is no accident. This was perpetrated by His Majesty's Home Department. However, with regard to the Calais children, problem solved in a matter of months. Meanwhile, after half a century, for the Windrush generation, the beat goes on. Dehumanization. After 52 years, it is no longer denial of constitutional rights, no longer denial of human and fundamental rights. It is very deliberate dehumanization of human beings, instigated by the worst kind of infestation. The United Kingdom government, represented by His Majesty's Home Department. Is the United Kingdom government so ignorant that they do not realize that to hell with the thoughts and beliefs of dead racists ruling from the grave, such as Maudling and Powell, this dehumanization is not done in the name of government or parliament, but in the name of their king. King Charles, are you cognizant of what is being perpetrated upon the Windrush generation in your name? Parliamentary sovereignty only exists because everything that Parliament does is in the name of the king, not government or parliament. It is time members of Parliament stopped behaving like parasitic insects. If you have not as yet realized it, you and your ilk are the ones depicted in this video as parasitic insects, feeding off the despair of innocent people. It is time to end the dehumanization of the Windrush generation. Over to you, Madam Secretary of State for the Home Department. End the dehumanization of the Windrush generation.